providing you back. You must be doing something right, or you must be doing something. Which option? Hopefully it's the former. I'm going to talk about sort of security risk when you outsource and how you can use the contract to manage that. So I'll set the scene. Then before we sort of get into the contractual provisions, think about what kind of due diligence you need to do on the service provider, and then look at some of the transition arrangements, i.e. when you're sort of transitioning in the service provider. Then look at sort of security requirements, some of the standards, and then some of the key contractual provisions. Then give a summary of recommendations, and then we'll have time for questions and answers. But if you've got any questions throughout, just feel free to holler. Now, I'm not going to talk too much about the benefits of outsourcing. We all know, it can reduce costs, improve efficiencies. You can focus on your core areas. So, there are a number of benefits of outsourcing. Obviously, there are lots of risks of outsourcing as well. And I think, the key mechanism to manage those risks are with the outsourcing actual commercial contract. Obviously, you can manage it through technical and operational reasons, but from a legal perspective, the key mechanism is to manage those risks through the contract. So, the problem with sort of security in outsourcing is, what is security? What are we talking about? Unfortunately, there's no sort of generally accepted definition. I mean, there's related terms in terms of confidentiality, availability, integrity, authenticity. Interesting to note that Security Standard 27001 talks about confidentiality, integrity, and availability. When you talk about security, it can mean different things in different circumstances. So I think just to set the scene, for the purpose of this seminar, when I'm talking about security, what I mean is a set of activities to protect systems from attacks or threats, and the state of being protected from those attacks or other threats. So just sort of bear that in mind when we're talking about security. So again, definitions of outsourcing, again, there's no clear meaning. It can mean different things in different circumstances. It can mean from subcontracting arrangements to alliancing relationships to partner contracting. I think a typical definition, one which I sort of use with my clients, is basically it's the process of transferring responsibility of a function or a process to a third party outside the organisation, and it may involve transfer of assets, it may not. So it's basically transfer of responsibility of a function to a third party. So also bear that in mind when you're talking about outsourcing. Why does security risk increase when it's outsourced, when you're outsourcing? Obviously, there's an increased number of users. There's obviously the users in the internal organisation, but there's going to be users in the service provider organisation. There's a loss of control as you transfer the responsibility to the service provider. And as a result of those two things, I think there's a greater risk for the breach of confidentiality. So in terms of managing those risks, in terms of contractual mechanisms, how can you do that? I think the key contractual issue, we've listed those out there, and I'll talk about them in the next few slides. But before we talk about the contract itself, in terms of managing the risk and the key contractual provisions, I think you need to do due diligence on the service provider. So if you're outsourcing an organisation, is outsourcing a function or a business process, you need to basically do the checks on the service provider. So what are the key areas that you need to focus on? I think there's three broad key areas. There's financial and commercial, technology and operations, and then customer interviews. And also, related to that, you need to do some security-specific due diligence. You need to look at the service provider's security policies, look at sort of network security controls, assess whether any third-party audits are being done or whether you need to do those audits. You may want to consider a risk assessment of individual delivery locations. By this I mean, for example, you're outsourcing to India, they've got some kind of development site in, say, Bangalore or Mumbai. You need to consider the specific site sort of risk assessments. It could be some other country. What are the specific risks in having a service provider located in those specific locations? And you also need to do on-site audits. It's all well and good, having all these contractual protections, but before you get into the contract, you should do site reviews, site surveys, go out to see actually those sites. to see actually whether they've got actually building in place and whether it is actually as they say it is. So in terms of financial and commercial due diligence in the service provider, what sort of questions do you need to ask? Well, I think some of the key questions is, what kind of past disputes have they been involved in? What kind of investigation, for example, have they been subject to any regulators investigated them? What kind of litigation have they been subject to, and have there been any security breaches in the past? Also, in terms of legal and regulatory compliance, have they been compliant with laws in the past? You need to evaluate the internal controls they've had in place. You need to review the business continuity plan. You may need to sort of analyse the supply chain to third parties. It may well be, you're contracting with them, but they're subcontracting, so you need to analyse the supply chain. Look at the client prioritisation. What I mean by this is, if you're engaging with a service provider who has a number of clients in your sector, and say, for example, something happens and that's relevant to that sector, which client gets priority? You need to assess that, because you'll be one of a few that they have. Who gets the first call effectively? And look at insurance coverages. What is their insurance coverage they have available? So it's all well and good having high liability limits, very strong contractual protections, but if they haven't got the insurance to underwrite that, it's quite limited, those contractual protections. Also look at their sort of accounting policies and practices in terms of their financial proposal. How do they propose to treat the assets, the transfer of assets? Look at their human resources in terms of potentially 2P implications, employment law issues, and obviously their financial proposal and cost. Is their financial proposal so good that you think, well, how much are they placing reliance? How much security robustness is there? How can they do this without paying for it? In effect, so I guess the statement, you pay for what you get, effectively. So if you pay very little, you can't really expect the robust security that you may have if you're doing it internally. So in terms of technology and operations due diligence, what you just do a general capability overview. I mean, these are just sort of things as an aim one. There's obviously more questions to ask, but as a high level, what's their security, intrusion detection, prevention systems? How do they manage the systems? What's their help desk like? Desktop services, LAN network, voice and telecommunication network. So what is their capability in terms of all these areas of technology? And in terms of project capability overview, i.e. if there's specific projects which you need the service provider to, develop and deliver to you, what's their capability to deliver them in terms of expansion, allocation requirements, in terms of, are they able to, resource up and be able to deliver those, particularly if you've got quite high requirements and they're not all sort of, I guess, there's peaks and troughs. So in terms of, if you've got high demand requirements, are they able to deliver those? What's their expansion plans, and then just in terms of transition planning, in terms of infrastructure and human resources. So all those kind of questions, I know this is not rocket science, it's all good common sense really, but it's very, I'm quite surprised at how many sort of customers don't do this sort of due diligence before they outsource. So it's best practice really. In terms of customer interviews, ask the number of customers, have they achieved their objectives from outsourcing? Obviously, one of your objectives, hopefully, is to reduce costs. Ask the customers, have you reduced your costs by going to the service provider? You may get some surprising results. What's their approach to contract negotiation? Because if the customers say, the service provider's really quite relaxed, they'll accept anything you provide to you, you go, well, you'll probably save on legal fees because you don't need me to negotiate that. But then you need to ask, well, if they're accepting everything, do they really understand what risks they're accepting? Maybe they just don't care. They're just taking view they accept the robust contractual provisions because they know, well, they haven't got any financial assets if they're in breach and sue them. Who cares? So you need to ask, how have the service providers negotiated the contracts with other customers? Transition planning effectiveness. It's all well and good, them saying we can deliver, we can do this. How effective was their transition? And you can only ask the customers who've sort of gone down that journey. You had these services in-house or with another service provider. Now you've been transitioned to this new service provider. How did it go? What were the pitfalls? What were the lessons learned? And then pricing transparency. Other clients aren't obviously, customers aren't going to tell you what price they've got these services for. That's fairly confidential. But you can ask about, general principles. Are they transparent in their pricing? Can you, for example, open book accounting? Do they allow benchmarking? All those kind of questions. In terms of service management, in terms of the efficiency of knowledge, how good are their support staff? What are their skills? How have they been trained? Are they accredited and so forth? In terms of reporting, what are the reports they provide? How efficient are they? Do they actually measure what you want them to measure? Frequency of employee turnover, that's quite important, particularly in terms of security. If they've got lots of people, coming and going, you need to ask, well, why? And that increases risk. The greater the turnover, I think, the greater the risk of security breaches are, just as a natural cause. People are leaving, people are coming, they take confidential information, loss of skills, and so forth. And then frequency of non-compliance rebates or service credits. Often, service credits are basically you've got service levels in an outsourcing contract. If they don't deliver the service levels, you get rebates, a reduction of your monthly charge. Ask your other customers, how much service credits do you get from the service provider? Because if there are a lot, you need to say, well, that means they're breaching service levels. So that indicates how compliant they are with the service levels with their existing customers. Then, in terms of service delivery, ask the other customers, what is their overall ability to meet the service level agreements? Do they meet the service level agreements? What about customer satisfaction service? What do the actual customers say? And then, as well as service levels during, the run phase, i.e. when the services are up and running or the system is up and running, what is the service level during transition? And that's really important because, the transition phase, that's when the teething problems are, so you need to make sure that service levels are achieved there. And then, what's their ability to meet business continuity and disaster recovery? If there have been events, how good have they been to recover those services, their backups and so forth. So in terms of transition, because there will be transition. Either there'll be a transition from your in-house operations to this new service provider, or from your old service provider to the new service provider. So, there will be transition in an outsourcing arrangement. So what are the issues you need to consider? I think there's effectively 3 stages. You need to look at, what are the current security operations, i.e. whether they're in-house or whether they're with the existing service provider. Look at, implementing an information security management system, and then, once transition is done, post-implementation assurance review, the lessons learned, how good was the transition in terms of making sure the security objectives are achieved. Security requirements, outsourcing contracts should have security requirements. And there's 2 real approaches to how the security requirements should be drafted. There's input-based requirements and output-based requirements. Now, in terms of input-based requirements, that specifies in details, as the slide says, assessment of risk, compliance requirements, security requirements. So they're quite detailed controls and levels of controls. It refers to a security standard, refers to a security policy, and then the customer gets assurance by the performance reporting and the security audits. Now, the features of input-based requirements is quite resource intensive because you need to prescriptively define what they are. You need to be quite specific about the requirements. And the service provider is constrained because it doesn't allow them innovation. You're basically saying you need to do A, B, and C. And then the risk is really transferred to you because you assume responsibility for fitness for purpose. So basically, you're saying A, B, and C, and if the service provider is A, B, and C, implicitly you're saying A, B, and C is what is good for your business in terms of assuring security. And service provider no obligations for controls not specified in the contract. So that's one approach to it. And I think in certain circumstances there may be certain security requirements that should be drafted from an input-based perspective. But I think most of them should be drafted from an output-based perspective. So that sort of, I guess, specifies in detail the assessment of risk and compliance requirements. So I guess sort of stepping back, an example of input-based requirements versus output-based requirements is, for example, an input-based requirement would be saying this is the kind of encryption technology you need to employ for transmitting emails or transmitting information over the network. That's it, and giving a particular encryption technology or encryption standard. Now, an output-based requirement would be quite high level and say you need to make sure that when information is transmitted on the network that there is no loss of data, for example, or no breach of confidence. So do you see the difference? You're more in the output, you're more focused on the outcome, and the input you actually specify, what requirement you need to be satisfied. And the risk is, that encryption standard may not be the appropriate standard. It may not actually achieve what you think it is. So even though the service provider may achieve that encryption standard, but you still may lose data. But the service provider won't be in breach because they've actually achieved their contractual obligations. So that's why outcomes-based requirements are more preferable. So in terms of, so basically you develop high-level control objectives, and then the service provider translates those objectives into detailed security policies, procedures, physical security, technical configurations, and so forth. Use 27002 as a guide. And then they operate the systems in accordance with those security policies they've developed. You require the service provider to provide a management sign-off, maybe commission engage a third party to do a review, and you gain the assurance by those third-party reviews and the managed service provider sign-off. So that the features or the advantages of using output-based requirements is it's much less resource-intensive than you specifying input-based requirements. Service provider has flexibility in the sense that you're providing what output or what outcome you want. It's up to the service provider to decide how to deliver their output, so that outcome, and so they can be quite innovative. In my experience, initial costs from doing output-based requirements, initial costs probably are higher to the customer initially. But I think overall, over the term of the contract, I think it sort of balances out, or might be even lower than input-based requirements. And I think in terms of the assurance approach, this kind of output-based requirements means regulatory compliance. For example, if you're an organisation regulated by the FSA have got guidelines on outsourcing, and basically one of their guidelines is saying that you need to draft security requirements or structure security requirements in terms of output-based requirements. So if you're in that industry, you will be meeting your compliance and regulatory requirements. Does this all make sense? Any questions? So in terms of security requirements, there's quite a number of issues here. First one is, I think, when do security requirements become effective? Now, I've seen lots of outsourcing contracts where basically, because lack of time, lack of effort, people say, look, we'll sort of park the security requirements, and we'll make draft the security requirement within 30 days, 60 days of contract signature. I would really resist against that, because that's effectively an agreement to agree, and it's unenforceable. So if you've got that contract, if you've got that wording in the contract, you've got very little comfort that if the service provider doesn't do that, you've got no comeback. So what you need to do is try to avoid that situation and do all the security requirements before the contract signed. But if you can't avoid that, what you need to make sure is you've at least got high-level principles for the security requirements. So you can actually point to some principles, and you're not basically drafting from scratch or open page, within 30 days. You've got some high-level principles that you can turn to. Inappropriate focus on solutions, not requirements. Sometimes, when you're getting in negotiations with the service provider, they'll say, we've got all these solutions, we can do A, B, and C, you get a bit, desperate. But you need to sort of step back and, focus on what's important to you, what are your requirements, rather than the solutions of the service provider. The next point, that's quite a difficult one. You need to, get the right balance here from too much detail to too little detail. You can have a lot of detail. Obviously, security requirements which run on for like 40, 50 pages. I've seen ones run off to half a page. I mean, those are extremes, but you need to get the right balance there between too much and too little detail. Another one I've seen is, I'm not going to ask how many of you have done this, but copying security requirement from a previous transaction or another customer. These need to be quite specific to your operations. I've seen ones where they're cut and paste and they haven't even changed the names of the parties. And that's a big clue. So, you need to, if you do that, I'm not saying you need to always reinvent the wheel. If you're using it from a previous transaction or some other customer, make sure you review it, make sure it's appropriate to your needs rather than just cutting and pasting it. Internal security policies of the customer. Often you say, the service provider needs to comply with our internal security policies. If your internal security policies have gone through a lot of robust review and rigor and quite recent, up-to-date, that's fine, but often these security policies have been drafted 5 years, 6 years ago. They haven't been reviewed and refreshed, so you need to be aware of that before you sort of the service provider to comply with that. So, make sure that you only get the service provider to comply with things which are fit for purpose. In terms of security requirements, some people overlook future changes to security requirements. So, output-based requirements, hopefully that shouldn't be a problem, but it was input-based requirements. There's new changes in technology, as you know, there's new ways of doing this, so you don't want it to be constrained at the current day. You need to make sure there's continuous improvement and it complies with new changes in technology and ways of doing things. But when you're looking at security requirements, you need to think about the different security requirements. Again, this is not rocket science, all fairly common sense. Physical security, for example, physical, restrictions in terms of doors and, in terms of, fences, in terms of, actual building security and physical security. That's one of the security requirements you need to cover in the contract. Then there's technology security in terms of technology for prevention, detection, mitigation, and limiting impact of security breaches. And then there's non-technological sort of security in terms of processes and procedures. So all those sort of three aspects need to be covered in the security requirements. And then you need to do regular review of security requirements. It's all well and good signing the service provider saying they need to comply with these security requirements, but you need to review them. You need to monitor and test them. If there's a material change to your business, for example, you acquire a business in some other location, you need to make sure the security requirements are appropriate to that location. Changes to technology. There may be changes to internal and external threats. What I mean by this is, you may be thinking you're operating in a fairly, non-competitive market, but all of a sudden it gets regulated and becomes quite competitive. So you need to sort of monitor those sort of macro environmental factors. And there's operational changes as well, which need to be monitored and implemented and the security requirements adapted to reflect those. So there's a variety of security standards. I'm not going to go through all of them. The most common ones are the common criteria, ISO 27002, 27001, COVID. I'm not going to go about the pros and cons of each of them. I think each of them have their strengths, each of them have their weaknesses. You need to consider what's appropriate in your circumstances. But I think that the main limitations with these standards is there's sometimes a lack of flexibility. There's obviously a cost impact, particularly if you want to get the service provider accredited to a service. If you're basically telling the service provider you need to be accredited to the standard, there's going to be a cost impact, and then we'll transfer that to you, and you'll notice that in your pricing. And sometimes there's a lack of specificity in terms of these standards. Because they're standards, they're quite generic. They're useful guidelines, but they're not the be-all and end-all. So just, bear that in mind. I mean, I think it's useful, but, just because you have it, it doesn't mean you've got a robust contract that will prevent you from, security breaches. So are there contractual provisions that you need to build into the contract? You need to have contract provisions that talk about incident management. So, what happens when there is a security breach? You basically need to think about, basically notification in terms of security-related incidents. What about incidents which aren't actually, isn't actually a security breach, but it was a suspected incident. So it's before it actually happened. The service provider is proactive and sort of recognise that there could be a potential breach. Monitoring in terms of successful and unsuccessful compromises. Contact by law enforcement or regulatory authorities. If someone, the police or some kind of regulator, contacts the service provider, you want to know that, because that indicates there is some issue. And then obviously if there's some kind of injunction or search order against the service provider, again you need to know that. So your contract needs to make sure that basically in those incidents or circumstances there's a notification obligation on the service provider to notify you. In terms of certification, make sure that you're certain over the correct standard. Refer to the correct standard. Make sure that the certifying body itself is credited, and make sure that the scope of certification is actually appropriate for the transaction in your business. In terms of security audits, who carries out these security audits needs to be obviously a recognised accredited party. What type of security audit? Not all security audits are the same. How detailed do you want it? How robust do you want it? What's the report that they're going to prepare? These third-party people undertaking security audits, and costs. Often, this is really a commercial point. Costs can be shared between you and the service provider. Costs could be borne entirely by you. Very unlikely that the cost will be borne entirely by the service provider. But you may want to put a provision saying that if, as a result of the security audit, this third party identifies as an issue with the security, that cost of audit will be, reimbursed. So, by the service provider. Fairly standard provision there. And then confidentiality. What other confidentiality provisions do you need to put in the contract? There's restrictions on copying information, restrictions on disclosing that. You may want to think about different levels of protection for different types of documentation. So there's certain documentation which have a higher level of protection, other ones have a low level of protection. And then, purpose, what can they use the information for? Obviously they'll need to access it to provide services to you, but what other purposes can they use it for? So you need to limit the purposes they use for confidential information. Termination rights. Now often contracts have, you can terminate a contract for material breach, or for a breach which is capable of remedy. If they don't remedy that breach, you have the right to terminate. Now, material breach isn't defined. It means different things in different circumstances. Lots of case law around material breach. And in some circumstances, you may think a breach is a material breach. In other circumstances, court may held it's not a material breach. So, what's the best way around this in terms of security? You may want to deem security breaches or breaches of various clauses, for example, confidentiality, data protection, as deemed material breaches. So by deeming them material breaches, you don't get into a debate when you go into court saying that breach is material, because the contract parties have agreed that it's a material breach. The remedy period, often, as I say, various sort of breaches, the service provider has a period to remedy. You may think that for certain security breaches, they don't have a remedy period because it's so, important to your business that they shouldn't have had that you want immediate termination. So you may want to consider there's certain provisions where they're not allowed a remedy period. Talk about dealing with certain breaches. Shared environments. Often service providers will have shared environments, shared infrastructure with other customers and so forth. So you need to understand the risk of this. So it's a couple of options. You could have an absolute restriction. You could say, our data needs to be held in basically a dedicated data center. You can't share it with any other customers. Obviously, there'll be a cost impact on that. Or you may want to say, look, if you want to share the infrastructure with other customers, you need to get our approval and let us know, what. We're not going to tell you the names of the other customers, but just tell you in generic terms, what type of customers they are. So you may consider if there are other customers with their shared environment has been shared with the someone who's not your competitor, you may take a more relaxed approach, but if it's a competitor, you may say, well, we don't want our data shared in the same shared data center as one of our competitors. So you need to sort of understand the risk and assess those. So other key contractual provisions in terms of service provider personnel, I mean, these are the individuals who are actually providing the services, have contractual obligations that they're screening and background checks and security vetting. You may want specific security requirements. Public sector contracts obviously have, SC clearance, DV clearance, so that's public sector clearance contract, but for private sector contracts you may want to sort of impose certain security requirements on individuals. Obviously they need to have the requisite skill. You may want a key personnel clause. What I mean by this is, often, when you're considering doing an outsourcing, you've got the sales team, you've got all the partners in the big four saying, we can do this outsourcing. They're like the A team. You go, oh yeah, we can buy these guys. Yeah, that'll be really good. As soon as the contract's signed, you don't see the A team. They've gone off to another client to pitch for their business, and you get the B or C team. So you may want to have key personnel clauses saying, these individuals will be dedicated to this business for a certain period. So that prevents them sort of moving on from somewhere, and gives you assurance that the people you're buying actually stay on into the contract. And then you want sort of removal rights. So if key personnel or if sort of important people don't actually perform as expected, or there's some kind of personality issue, you obviously need to bear in mind employment law legislation. You may want certain removal rights, saying we want that person removed, you need to replace them. So make sure you've got those kind of protections in the contract. So in terms of summarising all that, what are sort of the take-home? So you need to do your due diligence on the service provider before you outsource. You need to think about a security management transition plan. Think about input versus output requirements. My recommendation is the majority should be output-based requirements, but there may be certain circumstances where there's input-based requirements. Clear specification about the actual requirements, your needs, i.e. the requirements rather than the solution. Strike the right balance between too much detail and too little detail. Security standards, I think they're useful, but acknowledge and realise there are limitations to them. Have reporting and notification obligations on the service provider. Certification, think about who the certifying body is, the cost of certification. Confidential information, clear definition of what is confidential information. Talked about breach, deeming a material breach, considering whether there should be a remedy period. Consider the risk of shared environments, and then service provider personnel, all the provisions around those which we've talked to. That's really it. So, any questions?
You mentioned termination.
Yeah.
A number of provisions. What would you do if how would you try to capture the risk of the outsourcing company going into receivership?
Yeah.
And you maintaining access to your data? There was a recent case, obviously,
TUI
where
2.
Yeah. How they said you can have your data to pay for it.
Yeah. Well, I guess you would probably have contractual protection, but you try to include contractual protection. So, in the event of insolvency, we have access to data, and you can't actually charge for that. So you've got that contractual protection. In terms of sort of practical operational things, you may want to get them to place the data in a data escrow agent. You've got source code agents, but you've also got data escrow agents. Obviously, that's going to increase your cost. But if data is so important, you may want to say, you need to place the data of the most recent version of data with a data escrow agent. So if the service provider becomes insolvent and refuses to give you the data, you've got a trigger event and you can go to that third party and get the data from there.
Concentrated on all the things you've got to consider
in
setting up an outsourcing.
Yeah.
When you finally agree on an outsourcing contract, I'm presumably you've got in mind you've done it for a fixed period, or possibly unrenewable, or it's for an indefinite period, but you have some provision for terminating it. Not to a breach or anything, but just
termination of convenience.
On either side. So you need provisions in it to what happens at the termination. You agree to the transition.
Exit management. I mean, they haven't covered that. So you obviously need to cover transition at the start, but you need to look at exit management and disengagement. You know, how does that services get transferred either back in-house or to another new service provider? So you need to make sure you agree that as an exit management schedule. Again, it's similar to a security requirement. Often I see, you know, parties will agree an exit management plan within X days of contract signature. I try to, you know, I recommend to my clients don't have that because, you know, you're not going to get it done. You know, I've seen so many contracts where that's written in, and when I'm looking at it, I say, where's your exit management? Oh, we never agreed one. So, you know, so yeah, you need to make sure that's covered as well. Yeah.
And so, I think I'm correct with this because it was a long time ago since I looked at outsourcing contracts.
Yeah.
10 or 11 years ago when I first started doing it. And the idea of having we were putting a security schedule and things like that was really novel.
Yeah.
So do you think this is? Do people do this?
Yeah, no, I mean, I've seen it, particularly in the last 4 to 5 years, there is a specific security schedule. But I must say it's probably one of the ones that's one of the last to be concluded. Because it's one that people go, yeah, security bots will do with that, and yeah. So, yeah.
Picking up on that.
Yeah.
Cloud really gathering momentum now.
Yeah.
People are using it.
Yeah.
Companies supplying into it.
Yeah.
What advice and stories and
Yeah.
big risks.
Did you come to my last session?
Probably. Yes. I'm sure.
Yeah, I mean, cloud computing is another beast, really. I mean, it's a form of outsourcing, but the problem with cloud...
Picking up on the security now.
Yeah.
What would be hotspots? Maybe as a supplier, what do we need to think about?
As a supplier?
Yeah, supplying into the cloud.
Okay. Sorry, you're a cloud computing service provider?
Yeah.
Yeah, okay. Well, I guess, you know, data is really important for your customers. You know, data protection, you know, where is the data held? You know, I guess the ability for them to, as this gentleman says, to access the data if something happens to you.
The reliability, so.
Yeah. Yeah, and I guess ability for them to swap out. You know, if something goes wrong, the ability to basically get another service provider in. Because they don't want to be held to ransom to you.
Can I build on that?
Yeah.
I think the interesting thing about access to data is not just simply the access to the data, but where it is, at the end of the day, physically resident. One of the challenges that we've got, I think, in this space, particularly in the cloud context, is where at the end of the day any data is actually being stored, because it can fall into other legal regimes without you being aware of it.
Yeah.
So you've got the US Patriot Act. If you allow data to onshore into the US, then it's under US governance, and they can effectively, a kind of force majeure, claim access and control of it.
It's actually worse than that. It's not when it actually onboards to the USA. Basically, if you're contracting with anyone who has got a service provider who's got any links with a US company, for example, you may be contracting with a UK company. I did this, I was actually to the Home Office with Raytheon in the UK, but Raytheon in UK was owned by Raytheon USA, so that meant that the US Patriot Act would apply, because they're a subsidiary, so yeah, it is wider. But I think the Patriot Act gets a bit of a bad reputation. Everybody thinks, ooh, Patriot Act, but there's a lot of European legislation, France, Germany, which is probably the same as the US Patriot Act, but we don't know the name, I don't know the name of it, but it has the same impact. So I think that it's got quite a bad reputation, but there's other pieces of the legislation which has the same impact, i.e., you know, the government can actually get the data. I mean, for example, the UK, the regulatory investigating powers, you know, the UK government has access to data anyhow for certain circumstances. So yeah, I think that's something that you just need to be aware of and try to manage that risk.
Just asking a view on probably three things in sequence.
Yeah.
Firstly, in my observational experience, I would say that the public sector tends to be far more prone to going for the input specification.
Yeah.
Partly because of the attack coming down from above, but nevertheless it does tend to go that way. Secondly, that an input specification does tend to give you considerably less flexibility as time goes on if anything changes.
Yeah.
And thirdly, where the public sector has actually gone out to competition and had an in-house provider, where the in-house provider's won, it's tended to be cheaper in the long run.
Yeah.
Because when things do change, you can tell your in-house provider you're going to have to change. The external one wants more money. So really, those three observations, whether those gel with your experience.
Yeah, no, I think that's probably right. Yeah, no, I agree with that. Yeah.
I had an amusing experience about outsourcing this week. I was having my periodic tangle with Virgin Media, and I thought we were vague on the critical points.
What critical points? Go on. Tell us.
What outsourcing operators make all their profit, literally all their profits, from things that aren't in the contracts.
Yeah.
The Amazon consultants, the PTWs, the CSCs,
Yeah.
all of them have that as their business model.
Yeah.
So there's a compromise, as you say, between having a very comprehensive, lawyer-friendly, can I say, sort of contract, and a workable contract.
Yeah.
I've got to a vague, like how to strike that balance, because no one's managed it yet, I think.
I mean, I guess the contract that that needs to be done. I think, if you're a customer, and when I'm advising my customers, when they're putting a contract as part of the RFP process, is send out a robust contract, but it needs to be fair, because you don't want to pass all the risk to the service provider, because they're going to either not bid for the work or price for it. So you need a fair contract, but it needs to be robust. So I think, what is a fair contract? Well, I think that comes from, you need guidance from your lawyers. So you need someone who's experienced and who can tell you, this is a provision which, most service providers would not accept. So there's no point in putting that provision in a contract. Or this is a provision that's fairly market practice. It's fairly standard. So I think you need guidance from, your lawyers on that front, what a fair contract and what the right balance needs to be done. And it's all about risk as well. You need to think what your appetite for risk is. If your appetite for risk is quite large, you may take quite a flexible contract, or a contract which isn't as robust if your risk appetite is much lower, I guess.
If lawyers are working on an hourly fee, do they have a proper incentive for being sensitive?
I think this is getting a bit off piss, but yeah. Well, it depends on what your relationship with your lawyer. My clients, come back. I like to build a long-term relationship. There's no point, screwing with one client because they're not going to come back. So, it's your relationship with your lawyer. I agree. The hourly rate isn't, conducive to getting the contract done. But I do work on fixed price, fixed fees, and if we can scope the work. So, different models. Yeah.
Sam, if I can sort of again pick up that discussion, and I think the assertion that all outsourcers make their money based on their extras, perhaps pushing the margins a bit. But what I found interesting in your presentation was you referenced a number of times to costs, and therefore to the subject of finance. The most effective outsourcing arrangements I've been a part of, either having to deliver them or requiring them, has been where there's a triangulation with a finance type. Because one way that I found that you can balance this prescription or how much input-based and how much output-based is actually the mechanisms you use to resolve the problems. You put quite an emphasis on transition and before that on due diligence, but it actually works the other way up. I would expect an outsourcing organisation to want to take a look at me as a potential customer. Now, it's sometimes difficult to do that before there's ink on paper from the supply side, but part of the transition plan can include a reverse due diligence, a discovery phase, so that when the skeletons in the wardrobe start getting observed, who pays for what when the resolution comes. And that's actually what the BBC had to do when we outsourced, because at that time I was with Siemens, and they outsourced BBC technology to us. There was a £1 billion discovery budget for all the shit that we knew would be found by the fans to mix them up.
See, if I was actually for a customer, I would resist having that discovery thing. And the way to manage that risk is saying you do the due diligence before the contract's signed. But in reality, that's not often possible. So that's what's been proposed. And if there is some kind of discovery or post-contract verification period, I think if you're a customer, what you need to make sure is you understand the parameters. So it's not an open-ended checkbook. There's various parameters. It's time barred, it's capped, and all that kind of stuff.
Exactly what we ended up doing. It helps that. It's not a forever finding of new things to make money on the back.
Further on, you talk about the legislation. If your supplier or outsourced team is based in the other country, like India or Brazil, so how do you enforce the legislation Because it's going to be different in this country to the other country.
Yeah. Well, you would want it to be UK law. So it's UK law. So that they're governed by UK law. But in terms of enforcement, I guess you will have to enforce UK law against that party. I mean, often you would want to contract with a UK entity, and then even though the UK entity is offshoring to India and stuff, you've still got that UK entity there. If you're forced to contract with an Indian entity, then you may want to consider mechanisms like arbitration. So a neutral venue, for example, Singapore or Switzerland or something. So they're forced to settle there. It's difficult though, but it's they're halfway around the world. So other ways you could sort of manage that is have some kind of third party sort of guaranteeing their financial performance or their performance obligation, who's based in the UK.
The best practice is to go for a UK-based company.
I mean, I can't. If a client says, it's got to be Indian law, Manila law, I'll say, well, you'll need to get an Indian lawyer, Manila lawyer, because I can't advise them that. I always say, UK law it should be your preference if you're contracting in the UK.
But the law, the country of the supplier is the dictator, where the law is based?
No, it's up to contract. You can agree which law. The parties need to agree. So we should always have a governing law clause. Because the worst case scenario is you don't have a governing law clause, and then it's up to common law to determine which law it is, and there's a whole lot of complicated rules. But best practice is to stay in the contract what the governing law is. There's two things, I guess. There's governing law, and then there's, I guess, the jurisdiction. So governing law is, UK law, Indian law, and then you could presumably have, UK law, and then you could have the jurisdiction that the actual courts that hold the dispute in India, but they would hold it under English law. It's a bit unusual, but you can have that, or the vice versa. You could have, for example, Swiss law, but the jurisdiction is the UK. So the UK courts get experts in, and you hear, it's under Swiss law. So there's two aspects.
So, as part of your presentation, you talked about frameworks and certification, and that being potentially being a requirement that your service provider has to achieve for you. You also talked about sort of supplier due diligence as well. I've seen in a number of contracts recently where a supplier has to hold or achieve a particular certification. And I think that's been done as a sort of shortcut around that due diligence piece. So I guess the question is, have you seen that? Is that sort of a trend within the contracts?
I've seen that.
Yeah. Do you see, is there value in that over and above doing the due diligence, and how do things like scope and statement of applicability come into that?
I don't think, as I said, the accreditation should be a substitute to due diligence. You may want to take the view that if they get accredited, you do less due diligence as opposed to none. But I think you still should do some due diligence because, security standards, it's not the be-all and end-all. It does go some way, but...
I think I've seen it in the contracts that I've seen as a shortcut. It's kind of like, well, if they've got that, then they're kind of good enough and we don't need to worry about it.
But that takes you back, doesn't it, to Sam's comment about what is the scope of that certification anyway. But a 27001 type certification is based on an agreement of scope and a consensus on what the risks are. So at the very least, as a due diligence, I want to see that their assessment of what the risks they have in running my services for me.
And you would get a statement of applicability as well, So I guess that was the question.
I think they go hand in hand, really.
They see hand in hand.
Is there a rule of thumb saying that if outsourcing is not going to save you a certain percentage, it's not worth the risk?
No, I haven't come across that. No.
So what sort of percentage savings are people looking for?
Varies, isn't it? Depending on the business case of the individual business and what's being outsourced. I mean, it's not just cost savings, is there? Some people outsource because, it may cost them more, but, they just want to focus on their core area. They don't want to do this, it's not within their skill set, or, they want to focus on other areas.
How many companies, Sam, have seen this as a mechanism to do the primary driver for doing this is about transfer of risk?
I think the majority there would be a trip, one of the elements is transferring the risk here. So I would say that's probably inherent in most outsourcing contracts.
Transfer of security risk.
Oh, you're talking just about security? Probably half-half, I guess? Yeah. I mean, there's some organisation who take the view that even though we're going to outsource, we're still going to accept responsibility. We don't want to transfer that risk. And that's really important to us.
Can you actually transfer risk? In a sense, you're probably still responsible.
Well, contractually you can transfer the risk, but legally, I mean, if you're in a regulated industry, for example, FSA, you have the primary obligation, even data protection, as a data controller, you're the data controller. Data processor doesn't have any obligation. Only obligations it has in terms of the contract. So, the ICO will come against you, but contractually, if you transferred the risk, you would have an indemnity or some kind of stuff. So, yeah, they would come against you, they would fine you, but you would try to get that reimbursed through the contract. So, yeah, you're right. Legally, you can't transfer the risk, but contractually, you can.
And with security, the loss of reputation is usually the bigger cost if there is a breach anyway, which you can't transfer that to supplier.
But you're only ever really sharing elements of the risk, because at the end of the day, the system users are still your personnel in all probability. And in the presentation, you talked about more the deliberate threats from outsiders.
Yeah.
But you've still got the accident by the insider, let alone all the other dimension. So it's an interesting sharing of risk, and you've got to work through which bits are still with you and which are in the contract.
Yeah. The other thing I didn't touch upon, you touched upon about the loss of reputational risk or the liability. Often, outsourcing contracts have a limitation on liability, 100%, 150% of the charges. So you may want to consider there's certain categories of loss. You may want to say you've got unlimited liability or a higher cap. I mean, typically I've seen data protection being uncapped, security breaches being uncapped. So you want to make sure that your liability cap doesn't cut across those breaches. Otherwise, 100% of the charges may not go very far in terms of security incident.
Just out of interest, these are freedom of information requests.
Yeah.
Which the public sector are bombarded with constantly.
Yeah.
When they suddenly hit the third-party supplier doing this, is there a war?
Well, you need to make sure that the contract contemplates that. So, if I was acting for the customer, I would put a clause saying if there's a subject access request or an FOI request that comes to you, supplier, you need to basically tell us about it and then cooperate with us to make sure that we can fulfil our responsibility.
Can the third-party supplier of an outsourced service be obliged under freedom of information? So, in some ways, you can actually shield yourself from freedom of information. Because you outsource it, but you don't want people to know.
No, because you have that obligation, regardless.
Even though the information is within the outsource.
Yeah.
So they're not protected.
Well, they're protected. You're not protected.
The information request cannot be denied on the basis it goes into a third party.
Right.
Because the information is still yours.
An interesting state. There's an interesting case study people might want to read, which is about the BBC outsourcing that was just mentioned. The National Audit Office actually did a very long report on it in 2006 about the value for money element of it.
Yeah. Was there any value for money?
The security bit was it.
It looks like good reading. Of course, I'll bring that to a close.